I'm the chair, Julie Ryan Caputo. Let's have a quick roll call. Terrence Bond, vice chair.
Present.
Phil Cabucci. Ron Hogan.
Present.
Whitney Kimmerling.
Present.
Mike Loico.
Present.
And Councilmember Sean Parker.
Present.
Great. Okay. Let's, we have a short agenda today, just 3 cases to hear. Let's begin with the first matter. And let's hear from the city on case 2021-003.
Good afternoon, Board.
I believe it's 004. Yeah, 03 was withdrawn.
My apologies. Case 003 was withdrawn. We are going to hear case 2021-004.
Yes, this is for 78 Evanston Avenue, expired permit. This is a commercial limited zone, and non-owner occupied permits are available in that zone classification. On 9/11/18, a Type 3 non-owner occupied permit was issued. 2 website advertisements were posted on September 17th of 2018 and October 5th of 2018. On 9/4 of 2019, the permit was renewed. On 9/11 of 2020, the permit expired. It was discovered too late to renew the period. It was renew the permit. It was past the grace period of 30 days. December 18th of 2020, the first advertisement was removed. On January the 17th of 2021, a new application was made, and it was discovered that the property had advertised and operated on an expired permit. And so a BZA appeal was filed. On January 23rd of 2021, the second advertisement was removed. March 4th of 2021, scheduled BZA appeal, and no response from the appellant. And so it was removed from that agenda. And then the short-term rental Board of Appeal was filed. On April the 21st of 2021, the scheduled STR appeal, the appellant did not appear and rescheduled for this meeting. There are 7 documented stays after the permit expired. There was in October of 2020 3 stays, November of 2020 3 stays, and December of 2020 1 stay. There were no documented stays after the appeal was filed, and there were no documented complaints for the property in either the Metro Hub or with the host compliance hotline.
Very good, thank you. Does anyone on the board have questions regarding the facts? Seeing none, we can hear from the appellant. Could you please introduce yourself and give your address? Thank you.
Can you hear me? Okay.
Yes.
Alfonso Alexander. My personal address is 1100 Hibiscus Lane, Nolensville, Tennessee. May I proceed?
Please, go ahead.
Okay. Just want to, the reason for my appeal is to further define the information that was just shared and share some of the backstory that I think the Codes Office may not be aware of, and to give some clarity, and then to ask that we have the ability to reinstate the permit as soon as possible. So what I can share with you is that sometime between 8/26 of 2020 and 9/15 of 2020, we came and tried to renew the permit by coming to the office with a check and the affidavit and leaving that at the front desk. The normal procedure had been to leave that at the front desk. The individual working at the front desk would take it and then get it to the appropriate person for processing, and then at some point the permit would be renewed. And that's been the process that I had followed since 2018, which is January of 2018 was when I first started working on this process. The reason I say sometime between 8/26 and 9/15 is because the check stub that I have has 8/26 on it, but I know from time to time we don't necessarily go that exact date. But I do know that some others were submitted in September, so I know it was prior to, it was by 9/15 that happened, but I can't today tell you the exact date. But it was somewhere between 8/26 and 9/15 of 2020, and that was when the renewal was brought there. Again, I've been doing this since 2018. I've not run into an experience where that has failed. Excuse me. But that is the process that we've done every time. There isn't a receipt that we would receive, but we would just be told that your check stub would essentially be your receipt, and then typically we'd see the check being cleared within the bank. Sometime in mid-December, we were doing some reconciliations of bank accounts and recognized that that particular check had not cleared. Did not know what the status was of it. At the time, wasn't really sure when we were looking at it, weren't even really sure what the check was for. We just knew that there was a check out of sequence that had not cleared. As we looked into it and investigated, we discovered that it was the renewal for this particular property. At that point, we changed the listing to a 30-day only listing, and went through the process to start trying to cancel stays that were in there. Then as we were trying to figure out and understand what maybe had happened, we still continued to try to operate the property at a 30-day listing after that point. So we were just trying to really understand if the permit was valid or not. E-permits was showing that it was expired, so that's why we went through that process knowing that it has to be a 30-day or more listing. Then in January, I thought that the best thing for me to do in this situation was to just go ahead and apply for a new permit. So I went through the normal process of applying for a new permit, and upon that attempt, I was informed at that point that the property would not be eligible for a new permit at that point because some rentals had happened since the expiration date. And I believe that was when the codes office was first made aware that the permit had been that it had been expired and that the property had been operated. So I do know that we did have some operations after the permit expired, but again, it was because we did not know that it was expired. And I completely understand that, we're responsible for that, but we, again, had just followed the same process that we'd followed since 2018. Then this is just some additional information just to clarify some of the things that were made in the previous statement. So we went through the process and applied for the appeal as it was noted. We were on the docket for March. We had gone through, submitted all of the letters, and done all of the things that we're asked to do as a part of that process. I think it was over 200 letters because of that, notification letters, and put signs in the yard because of that particular address is in an area where there's a lot of nearby properties. At any rate, I came here for that hearing, and once I arrived, I learned that the hearing had been changed for virtual instead of being in place, but I wasn't made aware of that. And the young lady who I think was the assistant administrator worked with me and one other person that was here to help us understand that, but then notified me that we had been removed from the docket because we'd not sent out the letters. And I said, no, we definitely sent out the letters. I got an email from a very nice lady in the codes office who had been helpful after that said it was a mistake, that we had submitted the letters because they have a return a stack of returned ones, which is, I think, the way they understand if letters have been submitted or not. And so they added us to the April docket for this board, which I think was your first meeting. And the information that we received said that the date was Thursday. And then I called, or I came, I called on Wednesday afternoon because I was told that the meeting had already happened. The owner of the property lives in Arizona, and the owner called me and told me that she heard that the meeting had already happened. I said, nope, I have confirmation via email that it's on the 21st. So unfortunately, I missed that. So I just want to make it clear that in both cases, I heard the statement that we didn't respond in March. We actually did, and I heard the statement that we didn't show up in April. That is true, but it was because of communication that we got said a day later than the meeting actually was. But my request here is that if you guys would consider a reinstatement of the permit, because, again, I do recognize that we're responsible for keeping it up to date. I have the check stub from where we tried to do that and follow the normal process, but we just didn't recognize that it had not been renewed.
Okay, thank you very much. Could I just clarify your experience of arriving in person? Tell me this process that you arrived in person with a check, and also a little clarity. You're with a group called Playlist, right?
Playlist Properties.
Playlist Properties.
Right.
How many properties do you manage? So just to get a sense of how many renewals you're doing on a yearly basis.
Yeah, approximately pre-pandemic, well, let me say now approximately 20. Just to give you some backdrop, 12 of our properties were on 2nd Avenue, and so they're destroyed. And then pre-pandemic, we had up to 48, if I remember correct, somewhere thereabouts. I personally have been involved with this process since 2018. And so doing roughly 40 or so a year in terms of either new permits or renewals.
And your experience had been that for all of those, you were able to appear in person at the reception desk in the codes office with your renewal application, your check, leave it, walk away, and everything would go swimmingly?
That is correct. And our situation may have been a little bit unique because up until a few months ago, our office was literally right across the street. We're at 806 3rd Avenue. So in the same building where 3rd and Lindsley is. And so for us, it was safer and secure to just walk them over here and hand deliver. So that had been our process.
Could we get a little clarity from Metro as to whether or not that process that was just described to us sounds like your experience as well? Is this something that may have happened? And I guess before we get to that, how is it that you have the check if the check wasn't cashed?
No, I have the stub.
Okay.
Yeah.
So you're saying the check got lost in the office?
Yes.
Okay.
I'm assuming
that's fine.
The check never cleared the bank.
Okay, but you hand delivered it
That's
sometime
correct.
before the 15th of September.
That's correct.
Can we get some clarity as to whether or not that's something that happens?
Sure, I'm happy to. Joey Hargis with the Codes Department. The process he described, sort of with our pandemic and the changes in that, conforms with what he's describing. We're currently working on ways to allow applicants to renew online to avoid having to come down or mail down check payments for that very reason. And to the applicant's testimony, to which the check is not cleared, clearly we've not deposited that. But his description of the application does sound during this period of COVID, but we're in the process of making changes to that process overall.
If I could ask a quick question. So what is Code's process for formally acknowledging someone's check or that they have made an application for a renewal in the event that you're allowed to walk up and sort of leave it there?
You know, those, maybe Debbie, you might be able to address. as far as the process, not something I handle on a daily basis, but they do come in by mail as well.
Right.
Just mailed in.
Right.
If they're mailed in, they're logged in at the main office upstairs. They log every check that comes in.
Okay.
And then we pick them up and we review them.
Right.
Now, if they walk in, prior to the epidemic, they would just come into the receptionist desk. We'd ask them to take a picture of the affidavit, and then the receptionist would bring it back to me
Okay.
to review.
Okay.
But once that started happening, they would just drop them off at the guard station.
Right.
Mr. Alexander, just to clarify, did you leave it at the guard station, or did you leave it with the receptionist at the front desk?
It was at the front desk. And I will say, it's funny, just had a conversation just before this meeting that a good idea is to take a picture of it, but I never did that or was never asked to do that.
Okay.
Not to dispute anything, but it's just never come up.
What we have now in the office is a lockbox at the front desk with the gate. And while we're closed to the pandemic, for all types of permit payments that are hand delivered, we put it in that box, and then the permit issuance folks one person has the key to get into that and secure that box. So we've made some changes
Okay.
in addition to.
And at the risk of monopolizing this conversation, one last question. During this, difficult time of renewals and skeleton staffs here and there, how many other renewals did you, I understand you have other properties, how many other renewals did you pursue in the same fashion and successfully have them?
I would say no less than 10, but the process changed kind of shortly after that, where we would put the package together and then scan and email the documentation in to an email address. I can tell you that email address. It's codes permit pay, I think. Yes, codes permit pay at nashville.gov. And once that happened, we would scan and send it in. And then within a couple days, someone would call us and take a payment over the phone via credit card. But I would say during this process, probably no less than 10.
Okay.
And let me just clarify, that would be both renewals and new permits, because I did do a few new permits during that period.
Understood. But you then said it was mid-December that you noticed the check hadn't cleared. Had you not noticed on, as you said, on e-codes that you showed as expired?
It's not been a habit that we would go on there and check, just because we trusted the process and it had worked so well before. So no, I had not.
Okay, very good. Thank you so much for the information. Any other members want to ask any clarifying questions?
Madam Chair, one thing we didn't ask at the beginning, and that's my apologies, whether there was opposition present for this case number 4 on 78 Evanston. Just affects the timing of the
Yes,
applicant's
absolutely.
thing,
Sorry about
so-
that.
No, that's quite all right.
Is anyone here today appearing in opposition to Mr. Alexander's request? Okay, thank you. So can we close the hearing and go to deliberation? Okay, very good. We'll close the public hearing on this matter. Any questions for Metro or any discussion you'd like to have?
Just for clarification, the penalty would be 1 year from what date?
This falls under BL 2017-608. And at that point in time, upon finding by the Board of Zoning Appeals, which is not you, but same thing as board, it basically is determined upon the information given to you, so you can determine what that beginning date is.
Mm-hmm.
I'd be curious what everyone's take is on the the documented stays, there are 7. There's quite a few after the permit was expired. I think that 3 in October, 3 in November, and then 1 in December, when, we understand that even by Mr. Alexander's explanation, by then they ought to have known. You could argue one ought to have known before then, but you could argue, oh, they saw the check hadn't cleared. There was a documented stay at that point. So I'm curious what my fellow board members would think is an appropriate date to consider as the start date of when there should be a pause in making a permit available, and how long that should be. Do we want to consider 6 months or 9 months, or stick with the 1 year, and from when? What are your thoughts?
I have a question about your comment about maybe you should have known by that time. Is this the time period, and this is a clarification from Metro, remember at the last meeting that we had, we discussed that there was a time period where permits would go out. They would get the physical documented permit once a year, and then it moved to where they may not get the piece of paper each year. Where does this fall in that time period? At that point in time, was it you didn't get the documented piece of paper in the mail each year? It was just open-ended.
The renewal notification has always gone out. That has not changed.
I'm talking about like the actual permit. Last time we had discussed that the permit itself would on the face have the date, and then you would get a new hard copy permit each year printed off to be displayed. And I was under the impression, and correct me for those of you who were at the last meeting, that at some point that changed and you didn't get a new hard copy permit in the mail each year.
I don't have a hard set date on that particular change. It's possible that kind of evolved over time, but there's nothing that I'm aware of that a date is written in place.
Okay, but the actual notification for the renewal itself would have gone out. Is this a time period that you were actually still sending a written renewal that said your permit expires on X date and you need to renew?
Yes, that portion has not changed.
Okay.
The renewal notification has been sent out consistently.
Joey, can I ask, Mr. Alexander wants to add some information. Do I need to reopen the hearing in order to allow him to speak? Okay. I reopen the hearing in order to hear
Okay,
from Mr.
I'm sorry.
Alexander. Go ahead.
I would like to offer just a couple things. The not receiving the paper permit happened well before this. I don't know the exact date either, but it's been at least a couple of years when we've seen we have received paper permits for renewals. So that happened well before this, because I didn't even know that ever happened, quite frankly. We were always told to go into e-permits and look in the corner, and if we wanted an updated copy, there's a place that says resources or documents or something like that in the corner once you actually are on the permit, and you click there and print from there. I would also share with you that we have always been instructed not to depend on a letter coming in the mail to remind us of a renewal, because it might not come. And that's why we put a system in place where we would come and hand deliver the checks, because in the same token, we felt like our check might not arrive if we're having to depend on the mail. So just want to, just fully disclose kind of the thoughts there. The last point I would say, I'm not 100% sure what the process is for understanding when stays occurred, but I think it has something to do with when actual feedback is posted on the sites. So if feedback, for example, if feedback was posted in January, I think the thought is that a stay occurred in January. If that's the case, I would just caution that, because some of the platforms, you can put a review out there and provide that feedback much, much longer after the stay. So just,
Wouldn't you guys have a record of your bookings, though, that would just very easily dispose of when the bookings occurred?
we do, yeah, absolutely. But I'm saying if Metro says the last stay occurred at some point,
Right.
I think the process for them is to look at reviews. And I'm just saying that's not a really most effective way to do that.
I don't believe that is how host compliance works, right? Don't they have some native software that can identify?
No, documented stays are actually based on reviews.
Based on reviews and the date they appear, is there some presumption that it's backdated by X, Y, or Z?
It can be, generally, most platforms give you a period of 10 days to 2 weeks in order to post a review.
Okay.
That's not true for and it's not true for like our own website. But I'm not
Are
disputing.
you quibbling with the idea that you had to stay in
do you have
December?
rebuttal evidence?
No, I'm not. I heard that and I thought, I'm really trying to be helpful, actually.
Okay.
Sure.
Yeah.
Well, I just wanted to make sure if you had rebuttal evidence as to those dates, then we wanted to make sure that that's heard.
Right.
Because that will impact, what we determine as the number of days where you might have been out of compliance after the expiration date.
Sure. What I do know is that we discovered it in December and we stopped everything then. So, I'm not arguing that point.
Okay.
Okay.
While the public hearing is still open, yeah, please go ahead.
Yes. I'd like to ask staff a question. There, on page 4 of the case 008, the documentation from the appellant, there's a reference to a code section that says, upon determination by the zoning administrator or the zoning administrator's designee that a short-term rental property has operated without having renewed a previously issued permit, there shall be a waiting period of 6 months from the date of such determination by the zoning administrator. We're talking a year, this says 6 months. What is that correct, sir?
That refers to BL 2019-6 that was issued or became law 12/13/19. So that does not align up with what was actually the law back at
Okay,
this
so-
period of time.
So, anyway, as we get to case 8, this is incorrect. All right, thank you very much.
I think that there are differences depending on when the STR first went into operation. So different laws will govern each of these, right? Okay. While the public hearing is open, would anyone else like to ask Mr. Alexander any questions? If not, we're going to close the public hearing. Okay, public hearing is closed. Would my fellow board members like to deliberate or make some suggestions about how this case is handled?
If I could interrupt just for a second, Alex Bonner with Metro Legal. I just want to make sure the board is aware that as far as the initial review, it's very narrowly scoped. The question is whether or not the the zoning administrator's initial review was in error or arbitrary. So that, I think, is like the first threshold question the board has to address before addressing whether or not there's any modification, adoption, or reversal of the 6 month or 1 year or anything along those lines. So just so everybody is kind of on the same page there.
Thank you.
I've heard nothing so far to suggest that there was an error as to determination of the law or the facts on those issues.
I agree as far as the threshold question.
Yep.
I agree as well.
Okay. Does anyone have any sense that this effort was in good faith and that there ought to be some relief granted?
I find it compelling that they've followed this process where they have come over and hand-delivered the check, and I think, with changes over the last year and handoffs of checks and that sort of thing, he's got the check stub. I could see how, during accounting, you would realize it at that point, and at that point, that's when he made the decision to switch to 30 days, cancel any bookings that are out there. I find that to be personally compelling.
Compelling enough that you think there should be some relief granted in the number of months that they are kept from pursuing a renewal or a new permit?
Yes, I would reduce the number of months. I don't know that I necessarily have a idea. I'd like to hear from fellow board members as to what your thoughts are on the evidence and the repercussions of that, or the implications of that, before we can sort of nail down a time period.
Anyone have a sense of what they think might be just in this case?
You know, if the board seeks to offer a reduction in the weight penalty, you know, I would suggest 6 months from today.
Okay. How does that sound to everyone? We have the option of doing it 6 months from today. I think we do, correct me if I'm wrong, staff, we do have the option to date the start date at another time, like
Right.
the first short-term rental hearing, which was admittedly somewhat confusing in its scheduling, and that does seem to have been not the fault of the appellant. Would you consider 6 months starting from the April hearing date?
Is that a question for me?
Yeah.
Oh,
Does that sound reasonable?
whatever my colleagues believe is reasonable in this case. I mean, it seems like these issues began really in earnest in December
Right.
of 20. So 6 months from April would be a modest reduction, but one that I think reflects the good faith efforts on the applicant's part. So I would support that motion.
Anyone else have any input?
I might say that that's a little long, in my opinion.
Yeah, I was thinking the same thing. I could actually go back even further in time.
Okay.
This might not be enough of a sanction, but I could almost see going back to December 18th and making it 6 months from that date, which would allow an application to go forward within a couple of weeks.
Pretty darn quick.
Right. I think given the totality of the circumstances, that's not unreasonable.
Okay.
If there was a custom of leaving the application materials at the desk, and there's an admission that there were some irregularities with how things are being processed, and I'm still not clear on how applicants were getting their materials acknowledged when they brought them to the desk.
Sure.
I think there's a lot of room for mistakes to happen on both sides.
Well, there's also the issue of appearing in person on March 4th, which gives
Right.
us another date to
Right.
work from,
Right.
and arriving and finding that it was actually an online meeting as opposed to an in-person meeting. So we were given the information that you didn't show up, but in fact, you just weren't on Zoom. You were
Right.
here in person.
Right.
We could use that as our date.
We could.
No strong feelings from anyone?
I tend to be more in Mr. Bond's
Okay.
camp on
Okay.
timeframe.
So starting from the December date, okay. So what was the December date that the advertisements were removed?
12/18.
12/18. So I'm going to make a motion that the permit renewal is acceptable 6 months from that date, and ask if I have any seconds.
Second.
If we could
Okay.
amend your motion, Mr. Chairman, Madam Chairman, sorry, ruling that either the zoning administrator erred or did not, I guess as the threshold motion. And
Okay.
then if you, whichever way you go, you can, as a condition of that ruling, we, change the timing of his renewal application to that.
Okay.
But to a colleague's point with Metro Legal, that's kind of the narrow band this board's tasked with is whether or not the zoning administrator erred in this instance. And if you did, fine, great. If you didn't, that's okay too. And then set your conditions if you want to waive those
Okay.
beyond the year.
Well, and then I move to determine that the zoning administrator did err in enforcing this 1 year from, I don't even know what date. The previous date. And do I have a second that there was an error?
Hold on just a
Okay.
second. I think the motion may need to be that the boarding administrator did not err, and that we can then move on to the question of what the sanction should be.
I think, yes? Okay, then yet another motion. I move that the boarding administrator, the codes administrator did not err
As to facts or law.
As to facts or law.
Right.
And do I have a second?
Second.
Okay. Do we need to vote then on that?
It can all be one motion.
Okay. And we move to reduce the wait time to 6 months, beginning December 18th, 2020, which would mark the date that the ad was removed.
I would say just for clarity, since you already made the initial motion and then moved again, I guess I would just ask that you either vote on the first motion and then move the second one in, or just make a comprehensive motion of both the determination of the zoning administrator and then also whatever the board's decision is, just to make it as clean as possible across the board. If that makes sense.
It does.
Okay.
But do that next time or do that now?
Your discretion.
We'll do it next time, because we want to vote, yeah?
Yeah.
Let's open the vote for granting the 6-month waiting period. Those in favor, raise your hand and say aye.
Aye.
Aye. Those against? Okay. The motion carries.
And I guess follow up with a motion that the zoning administrator did not err with regards to the facts or laws related to the previous case.
Okay, I thought we captured them last, but I move to determine that the zone administrator did not err in terms of the facts of the case.
Seconded.
All in favor?
Aye.
Motion carries. Okay,
Thank you.
thank you, Mr. Alexander. We appreciate your time and all your information.
Thank you. May I ask one question? So would I be eligible to reapply on the 18th of June? Is that the date or?
That's correct, Mr.
That's right.
Johnson.
Okay.
Work
All
with
right.
staff on getting together with them.
Okay.
To apply on that date.
Okay. Thank you. Have
Thank
a great
you.
day.
Chairman, if you, Mr. Chairman, to sort of, I realize this is the second meeting with this board, and we're all new. I'm new to this entire realm. If you'd like procedurally, at the Board of Zoning Appeals, kind of how we do, I read through this docket agenda, call for opposition if they're present. That way, we sort of set a framework of know how much time we've got. If you're comfortable with me,
Sure.
I'll be happy to do that in this case. So, the next case before the board is case 2021-006. Samantha and Nicholas Vaughn is the appellants and owners of the property at 710B North 2nd Street, seeks permission to apply for a permit earlier than the law allows. The appellant operated after issued short-term rental permit has expired, and I see the applicants present. Are there any parties here present either in support or opposition to the case 2021-6? Okay, you guys in opposition? No, in support. Okay. Any opposition present? Okay. Seeing none, the applicant will have 5 minutes to present his testimony to the board. That 5 minutes, sir, also includes your support here if they wish to speak to the board. Do that, and I'll turn over to staff to kind of summarize the events, and then we'll turn it over.
All right. Can you guys hear me well? All right, thank you.
Before you begin, we'll do the presentation.
Oh, I'm so sorry.
That's okay. Hey, we're all learning this.
This is really new to me.
This is involving a detached accessory dwelling unit, referred to in the codes as DADU. This is also an SP zone district, which is special planning. This zone district always requires a review by the planning department in order to see if the use of short-term rental property is allowable, which in this case it was. This is also governed by BL 2017-608, just as the last bill, so it was a one-year waiting period. On April 24th, 2019, a Type 1 owner-occupied permit was issued. There was one website advertisement posted on April the 27th, 2019. On April 24th of 2020, the permit expired. On July 20th of 2020, a notice of violation was sent by Administrative Services Officer Campbell Padgett from Codes for advertising and operating with an expired permit. On August 18th of 2020, the website advertisement was removed prior to the remedial time period, and the case was closed. On August the 19th, the appeal was filed, and there were 18 documented stays after the permit expired. four of which occurred in August of 2020. There were no documented complaints for the property in either the Metro Hub or with the host compliance hotline.
Okay, thank you. Does anyone have questions for staff? Okay. We'll hear from the appellant. Could you give us your name and address before you begin?
Yes, my name is Nicholas Vaughn. My address is 710 North 2nd Street, Nashville, Tennessee. This is our first go at doing a short-term rental. And I'm not the person to make excuses. We didn't realize, that the permit had expired. Once we did realize that we had made the mistake, we took the Airbnb we took the property off of Airbnb. We would like the ability to receive or get a permit, to renew a permit. And so we then reached back out and went through the necessary steps to sit here in front of you today. That's, like I said, I think not really understanding the process and the steps that needed to be taken in order to renew and things of that nature was the lack of knowledge that I myself and my wife had on our part. And like I said, once we realized that we took the property off of Airbnb.
Okay, anything else to add?
Unless.
Please step forward.
Should I?
Yeah, please step forward to the desk.
I don't know, do you just?
And Joey, how much time remains?
This one.
Oh. Could you give us your name and address for the record, please?
My name's George Solmers. I live at 806 Stockel Street. I too have an Airbnb property as well, and I'm in support of his renewal and his attempt to fix this situation.
My name's Tracy Collins. I live at 305 Hancock, also in the neighborhood. I also have an Airbnb, a dadu that I just started. And so, I think we're all just figuring it out. It's there's a lot to learn, and so we are just doing the best we can. And we're all individual homeowners that have, we're running a single Airbnb. We're not like a business. So yeah, and we're all neighbors and support each other in trying to do that.
Very good. Well, thank you for your comments today. Any member of the board like to inquire?
Would. Thanks for your presentation, Mr. Vaughn. Is this y'all's personal home that you've got a dadu in the back
Yeah.
of? Okay.
Yes, sir.
Thank you.
May I ask something about your ad? I've seen many of them that have, and you're required to post your permit. Mm-hmm. So among your photos that show your, coffee station and what have you, is your permit photograph posted among your pictures as well?
I believe so. I would have to verify that though, but I believe it is posted.
Is that, let me inquire of staff, is that required that the photo is posted of the permit or just that the number is posted?
No, ma'am, the ordinance states that the number is in the advertisement, website advertisement, and that it is clearly legible. It gives no additional information as to how or requirements as to how, just as
Very
long
good.
as it is clearly legible.
Okay, super, thank you. Any questions for the appellant?
Mr. Vaughn, it appears to me that there may have been a violation that was sent to you on July 20th, 2020, as far as having advertising with an expired permit, and then you had, is it correct that you had stays in August of 2020? Or can you provide some clarity on when you last had occupants in the Airbnb?
I believe the last occupant was in August, to my knowledge. Yeah, I believe the last occupant was in August.
Do you recall, Mr. Vaughn, getting a notice of violation as far as advertising or operating with an expired permit in July of 2020?
I don't remember the time period. I do remember receiving the notice, and I remember, making sure that we took it down. So.
I have a question for Metro too, and maybe I'm just missing it in the packet. Is there a copy of the notice from July?
No, there's a copy of the appeal. Mr. Vaughn, while we look up, I'm sorry. Mr. Vaughn, while we look up that violation notice, could you tell me from your records, we have that 4 documented stays were noted in August of 2020. This would have been after that violation notice was sent to you. Do you have records to tell us exactly when those stays happened?
I can see within Airbnb.
That'd be great, thank you. And is that the only platform on which you advertise?
Yes,
Okay.
it was just there.
Thanks.
There is not a copy of the notice included in your packet.
Okay.
So we had a stay that was booked August 10th for check-in August 28th through the 31st. Canceled. There was a stay that was booked August 6th for a check-in for August 9th through the 15th. And that's it. The others were canceled.
Okay.
Canceled by you or canceled by the guests?
I believe canceled. One was canceled by the guest.
Okay.
Let's see. Yeah, we just had one that was canceled by guest. That was.
Okay, great, thank you.
I'm just trying to get a little bit more clarification from Metro about the notice. And I know that the response was that the copy of the notice was not in our packet. Was the notice, what confirmation do we have that the notice was actually sent on July 20th, 2020? So for me, there's, I'm just trying to gauge notification with the notice and when the stays occurred.
Yes, ma'am, I'm in the process of pulling that up now.
Okay.
Just one moment.
All right, thank you.
And just to clarify, I don't believe Mr. Vaughn disagreed that you had received a notice.
No, yes, like I said, I couldn't tell you the time period that we received it, but I knew shortly after we received it, that's when we shut it down.
Okay.
Okay.
And Mr. Vaughn, so if I may ask a question about the process of shutting down your advertisements, when you remove an advertisement from Airbnb, do you actually have to request that it be reposted? Or does Airbnb automatically repost things?
As far as when you say repost, what could you
An
clarify?
advertisement. If you ask them to make an advertisement you had previously posted inactive or remove it from the site, would there ever be a circumstance where they would put it back up without your awareness or your consent?
It's not to my knowledge that would happen.
Okay.
Yeah, I'm not sure.
The reason that I'm asking is because I'm looking at the history of your advertisement activity, which is a part of our packet, and I show that as of December 24th, 2020, there was an ad that was reposted, and then it was requested to be removed, or it was removed, on January the 15th, 2021. Is that a result of actions that you took?
I believe that was, we wanted to show the property where we had pictures of it. And so my wife would just activate it so she could show the property, the pictures of the property. We didn't do it to list it back on Airbnb for stay.
Okay, can you sort of fill me in as to why it would have taken 22 days to do that?
I don't, like I said, to my knowledge, it was shut down right afterwards. It was not in an effort to list it back on Airbnb for
Yeah, I
rental.
see that there are no bookings in that period, but I was just curious as to why the relisting and then the.
I do know that, like, we had multiple people was asking about looking at the property. And so she was like, here, let me show you what the property looks like. And that's, yeah.
Okay.
There seems to be a similar discrepancy in our packet, we're told that the ad was removed on August 18th, which may comport with kind of the time when the notice had been delivered and you'd been discussing it perhaps, but then the property was relisted a few days later on the 24th of August. And stayed up for 3 days, and it was removed, and then it was listed again on the 31st of August and remained up until September 2nd.
I know that we had some issues with making sure that it was off, like we thought we took it off, but it wasn't off. So it could have been with us thinking that it was off and then us being notified like, hey, this is still on.
Right.
So that would be the only thing that I can think of. But I know for a fact that, even if somebody tried to book, which I can show you text messages from our previous stays where people have tried to ask us to book and we have told them no.
And you're aware, are you not, that just advertising is a violation? Whether or not you book any stays and have any guests after your ad is, or after your permit is expired, or if you're operating without a permit, just advertising alone is a violation. Are you aware of that?
I'm not aware that we were trying to advertise. So we weren't trying to advertise our property. We were showing it to to some people. That's what my wife was just showing it to. So we weren't trying to advertise our listing.
Right,
And
but you
also-
activated your listing in order to show pictures to people 3 times?
Yes, ma'am. Like I said, my wife was showing some pictures of our property that we didn't have pictures of. And she's like, oh, I have some pictures of it online. Here, let me show you. But it was not to list it.
If I may ask, so it sounds like what y'all were doing is, knowing that you weren't able to, you didn't have an active short-term rental permit, you were looking for long-term tenants, so
Yes.
30 days or more.
Yes.
Okay. Yeah, I just wanted to be clear.
Yes.
That's what I think we're
So
talking about.
why not change the posting to a 31-day rental, which would be compliant?
I didn't even know that you could do that on Airbnb, to be honest with you. Like I said, we were just, here's where we took some nice pictures of our property, and we had that already in the system, and it was like, here, we could just show you this. And to my knowledge, it was show here, take it down. And like I said, we didn't have any stays.
Do you have an update for us?
Yes, I can't confirm the date that the notice of violation was mailed out, but it was written on July the 20th, and standard procedure is it goes out that day or the next. And also, just a point of clarification, Airbnb has several different functions that you can use to take down your advertisement. You can completely remove it, you can sleep it. The sleep function, they will give you approximately 6 weeks, and then they'll repost the advertisement without your knowledge. But it sounds like in this case there was some manipulation done by the advertisement, the host. But as to whether or not it was, what the purpose of that was, I have no way of knowing that.
Do notices of violation go out certified mail, or are they just regular mail?
Regular mail, sir.
Regular mail, okay.
Okay. Any other questions for the appellant? Okay. So I close the public hearing, yeah, and open discussion with my fellow board members as to how you would like to proceed with this matter.
So I'll just share some thoughts, and then we can kind of work toward a motion of some kind. First of all, I think that it's clear that there was no error on the zoning administrator's part here. This is an expired permit, so I don't think that's really questionable here. But, I will say that when I put a lot of weight when neighbors show up. The neighbors that showed up do live close to the appellant, and from what I'm hearing, I know that maybe there was a lack of understanding about some of the process, but I mean, it appears to be the appellant was responsive to the notice of violation. I realized there were documented stays within that sort of month window after the notice of violation, but I do get the sense that the appellant was responsive to the notice of violation.
Go ahead, Ron.
I agree with your assessment, and I think, and it was almost a year ago now, so when it was done. So technically, I believe wouldn't he be eligible on July 20th to reapply?
It's my understanding that at this point, with the case being before the board, it's sort of up to our discretion, although we could, I believe if the board chose to take no action on the appeal or I guess that's if legal. Thank you.
I can speak to that. So the board could, as I discussed earlier, adopt, modify, reverse the zoning administrator's decision. So if that decision would ultimately be that the applicant could get the permit in July based on a year from the violation, you could simply adopt that as your decision, or as the council member said, you have discretion to modify that as well.
I mean, if we think that some degree of relief is appropriate, I mean, I think 3 months would get, heck, 2 months would 2 months of relief would allow the appellant to get
2
their
months
permit.
from today's date.
Well, 2 months shy of the year from the July date, the notice of
Gotcha.
violation.
Gotcha.
So, we need to set a precedent of like where we're starting the conversation from. We've done it in different ways, so.
No,
we
I
should- we
agree.
should
I
discuss
think
at
I
some
think
point.
that's a very fact-dependent determination, though, because in the previous case, we saw lots of effort to actually comply before the expiration date, and then we saw sort of efforts in the intervening period to do things. I think we have a bit of a different circumstance here, so I think we can probably justify taking a bit of a different tack as to where we place that date. I was going to suggest actually running a 6-month period from January the 15th, which is the day that the last advertisement was removed. And that would actually still put us around the same time. It would
Yeah.
be July 15th.
I think that would be the most generous position that I would support. And I greatly appreciate that the appellant brought neighbors who are supportive, but let's keep in mind, these neighbors are also short-term rental operators, so there is a, that they have a stake in seeing that, these matters are disposed of in advantageous ways to fellow short-term rental operators. So it does mitigate that appearance slightly. Were they neighbors who are not involved in this industry, it might have been more compelling. But I would support that 6 months from the date that the advertisement last appeared on Airbnb.
So just to be clear, if the appellant had not taken any action to appeal the case, that would be about a 5-day difference between what this board is deciding and what would have been the zoning administrator's finding. The 15th of July versus the 20th of July.
Right. I think, but since we're on record, having these deliberations and having these discussions, I think it's very important that we make clear, where we're sort of seeing as the troublesome moment in time. And I think here, the most troublesome moment in time for me is the date that the last advertisement was removed. I can't exactly speak to what led to it being posted and then reposted and then posted, removed, and then reposted again. I can say I don't find it especially compelling that that was undertaken solely for the purpose of showing pictures. I think those can be saved. The pictures had to come from somewhere, so you could probably you could even save them from the website and just send them to interested people if the intent is just to show the property. So I can't quite assign to that the weight that I would like to. And that's not to say that you're being untruthful in any regard. It's just the way that it appears. There are many other there are other ways to skin that cat, I guess, to use a turn of phrase. And so for me, the best date to actually say we should be looking at this date as most important is the January the 15th date, or alternatively the December 24th date.
Can I just get some confirmation from staff, based on what Councilman Parker just pointed out, that had the appellant taken no action to appeal this matter, he and his wife would have been eligible to apply on the leading up to the 20th, or would the date be from the date of the last violation for after the permit had expired? Could I get some clarification on that? Say there was no such proceeding, when would the clock start?
Typically, we've used the last dated stay. So it would be-
Last date of stay, okay,
Yes.
excellent. So it is actually a little more relief, because the last date of stay would have been the end of August.
If there was no activity, yes.
Yeah,
Right.
okay. How does everyone feel about a 6-month waiting period, which began with the date that the advertisement last appeared on the Airbnb platform? Is that something that we'd like to vote on?
That would put the eligibility to renew date or obtain another permit date at 6/24 then. Correct.
I trust you.
No, it was removed in January.
Right, and that's the date I'm proposing
Yeah.
that we go from.
That's the date I was proposing.
Oh,
we
I
go from. Yeah,
apologize.
that's when it
Yes,
last
yes,
appeared, did it
okay.
not appear on?
Yes.
Okay,
Yes, so then that would make it 7/15.
yeah.
I support that. Then, given that, are there any other questions?
No?
If not, if there are no other questions, I will make a compound motion that we find that the zoning administrator made no errors as to the facts or the law, and also that we impose, I guess, discipline, for lack of a better word, of a 6-month period starting from January the 15th of 2021, where the owner may not apply for a new permit.
Second.
Is that correctly stated? I
No
lost
one,
track
no
of
one
my
corrected
words.
you, so I think it's good. And I second. Shall we have a vote?
Yes.
Okay, all those in favor, say aye and raise your hand.
Aye.
All those opposed? Do you want to have any further discussion? Okay, all right, well then, the ayes have it, and the motion carries.
Yeah, right. Thank you.
Staff can help you. Person can explain next steps to the appellant.
David can. You can just email David, right?
Okay, Chair, the next case for this board is case 2021-008. Clearwater Holdings LLC is the appellant and owner of the property located at 446A Humphrey Street. We're seeking release from the mandatory waiting period. The appellant has operated after the short-term issue rental period had expired. I know the applicants are present. Are there parties present in opposition to case number 8? Seeing none. And with that, you'll have 5 minutes to present your case to the board.
Good afternoon, could you give us your name and address for the record, please?
Good afternoon. My name is Seth Klein from Collins Legal. On behalf of the appellant, Clearwater Holdings, my address is 1811 Fatherland Street, Nashville, Tennessee, 37206.
Very good.
I'm Jeff Reed. I'm the principal of Clearwater Holdings LLC, residing at 612th Avenue South, Nashville, Tennessee.
Brendan Carreri, 401 Bowling Ave, Nashville, Tennessee.
Mr. Carreri is our legal intern from Marquette University School of Law. And
Milwaukee,
this is his
Wisconsin.
first
Well done.
hearing, so I thought I would have him along. I appreciate you allowing him to be here.
Welcome. And Seth, could we get your last name again? I'm sorry.
Yes, sir, that's Klein, C-L-I-N-E.
Okay.
All right. Gentlemen at the table, before you begin, staff will present testimony. Go ahead, Mike.
This is operating with an expired permit. This is an MUL zone classification. Not owner-occupied permits are available in this zone classification. The MUL stands for Mixed Use Limited, and intended to implement the moderate intensity mixed use policies of the general plan. Again, we're governed by BL 2017-608. There are 4 units at this address, A, B, C, and D. On 13019, a type 3 non-owner occupied permit, STRP permit was issued for this unit, which is A, and the permit number is included in your packet. There were 6 identified website advertisements posted for the short-term rental property. One of the ads is for 2 of the units, advertising both in combination, and has the permits for units A, this unit, and unit C, pictured in the ad photographs. On 11/26/2019, the permit was renewed. On December the 11th, 2019, one ad was removed. On October the 16th of 2020, a second advertisement was removed. On January the 30th of 2021, the permit expired. On March the 5th of 2021, renewal documentation was received by the Code Department 4 days after the 30-day grace period had ended. On March the 10th of 2021, expiration letter was sent by the zoning administrator. On March the 16th, the third advertisement was removed. On April the 12th, the fourth advertisement was removed. And on April the 15th, the appeal was filed. There are two ads that remain posted as of May the 12th. The first ad, the last document had the last documented stay of March 2021. And the second advertisement is the previously mentioned 2-unit ad, which has the following documented stays: 2 in March, 1 in May of 2021. And however, these stays cannot be attributed to one unit or the other. There is an attributable documented stay after the permit expired in March of 2021. So one documented stay. There are no documented stays after the appeal was filed. There are no documented complaints for the property in either the Metro Hub or with the host compliance hotline.
Great, thank you. Any questions for staff before we hear from the appellant? No? Great. Go ahead, please.
Thank you. Again, my name is Seth Klein on behalf of the appellant, Clearwater Holdings. One thing that we would dispute on the onset was the multiple property listing. We are unaware of any listing of that type or multi-unit listing, so the only discrepancy that I would allege from the staff's reconciliation of the facts would be that. Nonetheless, the summary of the facts were stated, we believe to be true. To recap, a permit was issued on January 30th, 2019. The permit was renewed in January of 2020, and the permit expired on January 30th, 2021 rather. While the appellant did not receive a regular letter from Metro advising of the permit expiration, the appellant's management company applied for a permit renewal on March 5th, 2021 after noticing that the permit had expired or becoming aware of that. On March 10th, 2021, Metro issued a letter rejecting the permit renewal and returned the check for the renewal stating that the permit had expired. Prior to this point, the appellant was in good standing under the Metro Code and had received 0 documented complaints as stated by staff. Appellant received the March 10th, 2021 letter on March 15th, 2021 and immediately ceased all short-term rental activity for the property. Some of the background facts for this matter: the appellant lawfully operated the property for 2 years, and during that time maintained the permit and renewed the permit as required. Sometime in January 2021, there was a strain on the on the communication as a result of the COVID-19 pandemic and the transition between management companies for the property. As a result of this transition and the pandemic, the previous property management company failed to take the necessary steps to apply for the renewal of the permit or otherwise notify the new management company that the renewal process had not been completed. There was no notice received from Metro prior to the time regarding the upcoming renewal date. And on March 5th, again, when they realized the error, the permit renewal application was submitted. At that point, a letter dated March 10th and received on March 15th from John Michael notified the property permit had expired on January 30th and to cease all operation as they did. Noted in our appeal, we have highlighted screenshots where the property's listings were taken down immediately upon receipt of the letter from Metro. And then, according to an email received from Metro Zoning Examiner David Vrabet, the property is now not eligible for a new permit until March 2022 due to the documented stay in February, or when we would allege was February, but a review was left thereafter in March, unbeknownst to the appellant that the permit had expired. Our request for relief in this situation is, in short, given the unprecedented time and results of COVID-19, we would request this board to reverse the cancellation of the permit due to the failure to renew. Generally speaking, Metro will revoke a permit when there has been a codes violation for bad acts of an STRP operator. The Metro Code addresses the denial or revocation of permit upon 3 or more filings, and in the event that they should notify such permit holder in writing of such complaint. And before revoking a permit, they should give the permit holder 15 days notice of the written alleged violation against them. going down through that. And to your point, Member Hogan, I want to clarify that the law quoted from BL 2019-6 is actually applicable to this permit because this permit was issued in 2019. So that law in and of itself would be applicable in this case regarding the 6-month waiver. In our opinion, that would be our argument. But to that, it's undisputed that after a permit expires, that a new permit must be applied for, that the appellant failed to timely apply for, be approved, and receive a permit. However, in this case, there's been 0 complaints filed against the property, and through the date of this filing, there's been no determination that the appellants violated the Metro Code or any other STRP-related regulations. There was one documented stay after the permit had expired. However, the appellant was unaware of the expiration, acted in good faith, and took immediate action to rectify or otherwise remedy the situation. In short, all STRP activities ceased immediately. The appellant received no prior notice from Metro via mail stating the permit was about to expire, and made a good faith renewal filing prior to receiving the permit cancellation letter. Again, while there's no level of culpability, the appellant at all times acted in good faith, and the actual renewal permit was submitted just 4 days after the 30-day window.
Very good, okay. I think the allowed time is up.
I would ask that, given the precedent of all the other hearings before today, that I would be allowed an additional minute or two to finish my brief.
Well, can I interject something?
You can.
Just for a minute or two. I'm Jeff Reed. I'm the principal of this company. Just let the board know what was happening. We were changing management companies in January and February of 2021. The old management company failed to renew the permit. So we thought the permit had been applied for. They had not applied for it. By the time we realized that, we had it renewed in March, and we submitted it for March 5th. That was 4 days later than the grace period, so we were late by 4 days on it. I did have one rental in February for, I think, 4 days. So that's the only rental I'm aware of that has occurred in that property. And when we were notified by the letter from Metro that there was a violation, of course, I was not happy to learn that when I heard that, because I thought it did not reflect well on my management company at that point, which is one of the reasons I was changing management companies. And we immediately ceased all activity, took down all the ads off Airbnb, suspended all those, and we've not rented it since. So we got the notice from Metro. I think the letter was dated March 10th. We got it March 15th, and as soon as I received it, it was immediately taken down, and we've not rented it since. So we've had the STR permit for a couple of years now. I know the STR rules. That's why we've had the permit in place beforehand. We renewed it 1 year earlier. We would have renewed it this year. COVID was going on. People were out of the office. Things were not being handled very well on the management company's end of things, and it slipped up, and we did not catch it until March 5th when we applied for a renewal. That's before we had received any kind of notices from Metro of any kind of violations. And the other thing to note is, historically, I've got 4 Airbnbs, and historically I've always received a renewal notice from Metro. Not that Metro has to send it, but they will send it a couple of months in advance of us having to renew the permit. And I've been getting those for several years now. We did not receive that in this case for this unit. I don't know if that's because of COVID. I don't know if it's because of the mail or what was going on. But that's always been a safety trigger for us, even though we did keep up with it, to kind of, as a reminder, to get the permits renewed. But obviously we were late by 4 days in this case, we would, with respect to the co-listings, this one building, it has 4 units in it. All of those are Airbnb units. I have letters which I can share with you from 2 of the other owners of Airbnbs in that unit who are okay with me getting renewal on the permit. The third one would be okay with it too. I just didn't get a letter from them. But so if there's a co-listing between my unit and another, there's some error on that, because that's not anything I'm aware of. There is no co-listings of my unit with any other unit, and my unit has not been listed since March 15th.
Okay, very good. Thank you.
Thank you.
Could we get some clarification on this May stay? Because it's our understanding that there was a documented stay in May of this year.
There's been no stays since March 15th.
Yes, ma'am. According to Hope's tracking, we did have a stay and I have a printout of the advertisements from March the 12th. The combination advertisement has photographs of units A and C's permits.
Mm-hmm.
That is the dual advertisement. The single advertisement has, and I think that there was, yes, the May stay is on the dual advertisement, and it
Okay.
cannot be attributed to either unit.
Yes, but both of those units belong to you.
No, they do not. I only have Unit A.
Okay, so you have an ad.
I do not have any ads running, so I have
Could
zero ads
I
running.
finish my question?
Sure.
You have an ad in conjunction with another owner? Is that correct?
No, that's not correct.
So the double,
There are two units there, B and C are rented together. So those are the units there, that they co-list those units in that building. There are 4 units total in that building, A, B, C, and D. B and C are the 2 units that are listed together. I know the people who own those units. They're not, I'm not affiliated, I don't own those units.
All that I can attest to is that the advertisement has photographs of the permit for A and the permit for C, and I have a copy of that here.
so if B and C are owned by an individual other than you or other than your company, how is it there's an ad for A and C that appears together?
It appears that it was a mistake on the management company if they had listed, if they did not remove A from that joint listing. A was never joint listed with any other units.
Does the same management company handle all 4 units in the building?
They did originally. Originally, that building was built by one builder, and his management company that he ran initially managed all the units. The managements for B and C were changed
When?
sometimes during 2020, I believe, so in 2020. And, yeah, so there's a different management company for B and C.
And I think it's a point to note that permits are readily available and copies of permits are readily available online. So if that was an error from a management company in pulling the wrong unit permit, there's no way to determine that. However, again, it is our position, my client's position, that there's no dual listing. It's not one that I've ever been aware of or we've ever discussed outside of the single stay that occurred in February.
Okay. So another point of clarification, we have a matched property listing here that only lists A, that has your property, A, correct? A like apple, we're in agreement?
Correct, yes.
Okay.
A.
So that the listing was, we won't go through all the details, but starting with March 10th, it was reposted after having been removed February 27th. It was removed again March 16th. We have 3 documented stays there in March, 1 in April, and that the listing was then removed April 4th, and then reposted on the 7th of April, reposted, it must have been removed and reposted April 9th, and then removed April 12th. And you, of course, as you said, you know this system well, so you know that advertising a short-term rental is a violation, not whether or not you rented it. It's advertising it alone is a violation.
There have been no postings. I have not posted any advertisements after it was taken down on March 15th. March 15th is when we got the notice in the mail regarding the violation.
This matched property listing is only for A, though, which is your property.
Right. And I was going to ask, you're familiar with your Airbnb associated file number, correct?
Yes.
So if I called it out, you could tell me whether this was accurate.
I don't have that information in front of me. I would need, if you're referring to the 2021-0023-047.
I am not, actually. I'm referring to listing, it's AIR 425-84155.
And that is a reference number to Airbnb. I'm sorry, I don't understand your question.
I believe it is.
That number is not familiar to me, no, sir.
Okay. Let's see here.
As far as the documented stays go, I don't know, there's been no documented stays, there's been no stays at that unit since March 15th. So, there's been none.
Ms. Ryan, could we get a copy of what you're reviewing there to maybe better understand and provide an explanation?
are we able to provide this matched property listing that comes from the vendor? Debbie, is there a clean copy of the packet?
Generally, we get submitted, well, previously for the BZA court, we would get submitted the packet prior to the hearing, and we could review that and be able to answer any questions you have. That has not been the experience that we have had with the STRP court at this time. Also, for points of clarification.
We'll take that under advisement.
With regard to the confirmation receipt for renewals, I wanted to point that out, Mr. Bond, your question at this time. There's still, even with the Dropbox, no way to confirm without taking a picture with that metadata that you submitted that check and that renewal. I thought that was a very good point. It's something that we struggle with on our end, trying to prove that, you know, in these situations.
So,
Can I clarify something? I think when we're looking at this, and now you've got a copy of it as well, when we're looking along the right-hand side, these listings are all assigned an identifier number. So you've got several of these that have different numbers as far as when things are posted and when they're taken down. And if I am understanding correctly, the listing number that ends in 155 is for this quote-unquote joint listing, okay? Now, Unit A, though, the listings for Unit A, which are owned by our appellant here, end in 006. Am I correct on understanding that? Does anyone have a different understanding?
Well, Mayor, as I stated initially, there were 6 identified advertisements for this property, most of which were removed prior to the permit's expiration. So that combined with the fact that there are 4 units in this building, it can complicate the situation a little bit. But I went through all of the advertisements very carefully, and the ones that I could identify personally by seeing the permit number in the advertisement are the ones that I set forth in my testimony today. And what I can verify based upon a review that I can physically look at and read was from March of 2021.
So there may be a variety then of these identifier codes associated with advertisements for this
In this situation, definitely so, because there
Okay.
were 6 advertisements.
Thank you. I'm just trying to understand how it calculates it. If I may ask this question, you said that you have, tell me when you got your new property management company.
We were in the process of transitioning in February to, and that's when the
Okay,
permit
so
is-
February 2021 is when you
2021,
got
yes.
your new management company. The other owner of B and C in the building got a new property management company in the fall of 2020 or thereabouts, based on your understanding,
Earlier,
correct?
yes, yes.
Okay, so, and their new property management company is not your new property management
No.
company, correct?
They're not.
So if we're seeing a joint listing coming up in recent history, you guys are not at the same property management company. Were you ever at the same property management company?
When the building was first built,
But
So,
within
yeah.
the last, we'll say, 9 months, were you
No.
at the same property management company?
we were
Okay.
not. No.
all right, to follow on that, so we're in agreement that 425-84155, as identified by Airbnb, as kind of your property.
No, ma'am, I would disagree with that. If you look at page 1 of the handout, it says 446 Humphrey Street, Nashville, Tennessee. Identified unit number is A. If you go to page 2 of that, which is the listing continued, the listing URL is airbnb.com/rooms/426050009. The host compliance listing ID is air 426050009.
Hold on just a second. I'm not seeing that.
I'm not seeing that either.
Oh,
I'm not
okay,
seeing
so
that page.
we'll go through this packet together, and it's on page 1, 2, 3, 4, 5. On page 6, the middle column,
Yes.
listing URL is the first line. If you'll see after airbnb.com/rooms/
Yes.
Yes, sir. That's what, to answer your question, Mr. Bond, that number is what I believe to be the reference number for Clearwater Holdings Unit 446A Humphrey Street.
Perfect. Then, in that case, the last date that I have that ad being reposted is April the 7th of 2021 with no removal date.
Well, sir, the reason why, if you look at above listing date, you will see that the date is 4/15/2021. So this report was prepared on April 15th. Therefore, any activity after April 15th would not be referenced.
Yes, no, I do understand that.
So if the listing or posting was removed, then it would not reflect in this handout.
Certainly, certainly. But I don't think that makes things look any better.
I agree with you. I understand. I'm not disputing that.
Yeah.
But and maybe my client can speak to, or if he has proof that he can provide to the board at this hearing to show where it was removed. But I agree with you, given on this handout and this listing, that it was reposted, and as of 4/15, it was not removed as of 4/15.
Right, right.
I don't have any knowledge of anything being posted after March 15th. So on March 15th, when we get the notice from Metro, I called the management company, directed them to remove the ads that day and take it down. I think I heard someone's reference a removal on March 16th, which will be consistent with what I told them to do on March 15th. So whether I don't have any knowledge, I authorize no one to post anything else after March 15th. I told them to take it down immediately. I expected them to do that. I can tell you, I've had no stays there. I've received zero income from that property since the February rental back in February. So, to my knowledge, I mean, I don't know of anything being reposted or being relisted. I've authorized nothing to be reposted after March 15th.
And just as a point to make, we filed this appeal on April 14th, 2021, in an attempt to get this permit back. It seems very counterintuitive that we would relist the property and advertise it against the law, given our efforts that we have made and our good faith efforts that we've notated in the other previous hearings before this to try and rectify these problems. So nor my client nor I can explain this listing and the reposting thereof. However, I can say that if you take the totality of the circumstances and the efforts that my client has made to rectify the problem, to take the necessary steps to reapply and cancel listings as we have stated, and then in line with the fact that we filed for an appeal on April 14th, we believe that would indicate that we were not in fact trying to advertise the property.
Could you please verify for me whether or not the listing is still active right now?
There's no listing active, no.
Can you verify that for the member?
If I pulled up this URL right now, it wouldn't go to your Airbnb?
To my knowledge, Ms. Kimberly, yeah, that's correct. It would not. Feel free to. I know this is a try the glove on moment to make a reference, but to my knowledge, it is not active. So I will see how this plays out for me. It didn't work out the first time, so.
I guess
I don't even know the Airbnb number.
Some real-time fact-finding.
It is.
If I may, just to correct a factual statement that was made, this, as staff has reported, this is governed by 2017-608, BL 2019-6, which I was a co-sponsor of. That came late in 2019. I don't know the exact date.
December of 2019. Yes, sir.
Yes, and this permit was issued January of 2019, so it would fall under the previous.
Yes, just to clarify, the 2017-608 was passed February the 2nd of 2018. The permit, as you stated, was issued in January the 30th of 2019, and the subsequent bills were 1633. It's September the 23rd of 2019, and then 2019-6. It was December 13th of 2019. So the last two bills were subsequent to the issuance of the permit.
For point of clarification, was there not a retroactive start date for those bills?
No, sir. The bill states that they are signed and then circulated, and then they take effect. So the date that the mayor signs it is the date.
I apologize to the board, Mr. Parker, Mr. Hogan. I apologize for the misrepresentation and the error in my brief.
It's quite all right.
Okay, any more questions? Oh, Whitney, go ahead.
The photographs and this listing that you have now seen in this packet, are these of your unit?
No, those are not my unit. I don't have those soap dispensers there in those pictures.
Okay, because this is something that I think we need to clarify. This unit, these photographs, if you go to the URL listed in this, it's still active. So, may I show you my phone?
Yes.
Go ahead,
Well,
go ahead. We are not standing on ceremony today.
I would also add for a point to both numbers listed on the top of this case listed for Airbnb, both actually list active ads.
Okay. Okay, so.
Well, on this, I don't know that it says C or A, but they're the same. You can match up some of the photos, I believe.
Yeah.
Here, and he's telling me that's not his unit.
As Ms. Kimberly's pointing out, if you could look at this page, there are two Airbnb reference numbers at the top. One that ends 009, which my understanding was you claim that as your own, and one that ends 155, which is not.
And that's solely on going on the information provided here, assuming that page 1 of 4 and 2 of 4 are the same, and given the fact that on page 1 it says the identified unit number is A. So now, there again, if this information is inaccurate, then I can only speak on what I have before me. But if it is, then I would urge the the board to consider accurate information, because if we're both reviewing inaccurate information, I think that it could result in an outcome that might not be fact determinative.
Sure.
Yeah, I cannot confirm whether this Airbnb number is correct for my unit A or not. I don't know the Airbnb.
Okay, may I ask another question? Ms. Kimmerling actually, when she showed you the photos, you referenced the soap dispensers. Is that the only thing that differs from your unit versus the photo?
The mirrors are different as well.
Okay.
So I don't have the hexagonal mirrors, nor the soap dispensers.
Okay.
And granted, the units A, B, and C are similar. The same builder built all these, so they're very similar in nature, but the decoration and size is different. So that's how I instantly recognize, with respect to the photo that was shown to me a second ago on the phone, it's not my unit, because I know the sofa and I know the chairs in there, and that's not my unit.
Right.
But, we realized the permit had expired, and before we received any kind of notice of Metro at all, on our own, we came and tried to renew it. We were 4 days late in trying to renew it, which, and once we got the Metro, when we heard Metro, they rejected our check and returned the check to us saying they could not accept the renewal because there had been a documented stay in February, which I didn't know that was a rule, but I understand it's a rule now. So, and when we got the notice from Metro, I took it down that day. I told the management company not to rent it anymore, to take the advertisements down, and it has not been rented since then. So, units B, C, and D, all in that unit, in that complex, are all Airbnbs. They have continued to be rented, I'm sure, because I'm sure their permits have not expired. So B, C, and D have still been active, but mine has not.
Quickly, may I ask, Clearwater Holdings, what other properties do you own? How many other Airbnbs or?
Four other ones.
4 others. Okay. So it is a sizable business, if you will. None of these are owner occupied. These are all non-owner occupied.
They're all non-owner occupied, yes. So 4 units. And I would say again that we have, and I understand it's our responsibility to make sure we know when our renewals are due. In this case, we typically have always received a letter from Metro a couple months in advance saying the renewal is due. We did not receive that this month, and I know that's my responsibility to keep up with it regardless of whether we got a notice.
Right.
But it was a change than what we previously have been experiencing.
We
And-
understand you shared that with us. Thank you very much. Let's,
And if I just may, to just one last point, Ms. Ryan, thank you. I do agree with you, and I see the point that you made with the 4155 number. So even carrying that over, the dates are still the same, Mr. Bond, as the other number. And I'm not sure, Ms. Kimmerling, if you pulled that number up on your phone, if that would show as active or not. But
it does show as active.
just for clarity for the court,
It shows as active as 2 units with something like 16, sleep 16, which in and of itself is a violation, but we're not going to get into that
well, we
today.
would dispute that, and that if there's any multi-listing with this property.
Okay, with that, nope.
May I
Ms. Kimmerling, go
clarify?
ahead.
I just want to clarify the timeline, because we've gone in a bunch of different directions. So I want
Yes,
to
ma'am.
clarify just simplicity timeline. Permit expired January 30th,
Correct.
2021, okay? 3/5/21, you guys filed your renewal documentation 4 days after the 30-day grace period. Okay, you got a letter on 3/10 from the zoning administrator telling you you've.
Permit expired on January 30th,
Okay, or the letter was dated 3/10,
received on March 15th.
okay, and then what you purport to be the ad for your unit was removed theoretically either on 3/16 or 4/12/2021. Thereafter, you filed your appeal on 4/15/2021.
4/14, I believe, was the appeal date.
Okay, now, the last documented stay, do you have your records of when the last stays occurred on this property?
February 14th through 19th.
Okay, were there any stays in March?
No,
No, and no stays since the February stay?
no, February 14th through 19th.
Okay,
We had one stay during the interim period.
And that goes back to, excuse me, that goes back to the platforms allowing that time after the stay to leave that review and that period of time thereafter.
right, I understand that, I just wanted to get.
Yes, ma'am.
And hopefully that was for the benefit of the board, not just myself that had gotten confused, but I felt like we needed a good linear timeline, so thank you.
Yes, thank you.
Thank you. Okay, with that, shall we close the public hearing? Very good. And I would open it up to discussion amongst the board members.
My first take on this is that we have some correct information and some incorrect information. And that because all of these homes are on the same property, or same strip of addresses, that it is, we're kind of limited in terms of what data we actually have to prove the case positively or negatively. So it's a little hard to clarify in my opinion, initially.
I think that's a good point, that the, initial set of facts, if you will, want to call them facts, put before us, we're a little more damning than perhaps they appear to be. I think I come back to the fact that the permit expired, and, we've heard a number of times, we were 4 days late. You weren't 4 days late, you're 34 days late. There's a grace period for a reason. When the grace is over, the grace is over. And in a case like this, where you have, this as a business, you have a company that has 4 units minimum, and, I think there's a higher degree of responsibility to be conscientious, in that one is doing this as a business, So, I understand there was a pandemic, but 3,505 permits were renewed between February 20th and December 31st of 2020. So it's not like it was impossible, and the pandemic didn't preclude all these people from getting their renewals.
I agree with you, Chair.
But as for, are we 100% sure that there was some documented stay in March or May? I'm willing to say that might have been conflated with the other listings. And perhaps the previous management company is somewhat responsible for trying to bulk up their listing on the backs of the appellant. But that doesn't change the fact that the permit expired. This is a company with a business that they're running. And that responsibility is a little higher degree of difficulty. Higher degree of responsibility, perhaps.
I would just love to know which Airbnb identifier is actually theirs. That would make.
Don't ask, we can't reopen the
I know,
public
that
hearing.
would just so clarify things for me, because what I'm seeing, looking at this again, is there is an Air 320-36492 that shows a last repost date of March 10th and shows a removal date of March 16th, which tracks with the narrative that we've gotten as far as, last dates of activity. And if that's the case, it doesn't, it certainly doesn't erase the fact that there was operation after, or there was operation from the advertising standpoint after, but it certainly makes, it validates everything that you're saying with regard to what you tried to do in the aftermath of the expiration.
When I put that number in, the
Yeah.
492 number, I get one of the Airbnb, oops, the page is not found.
Okay.
So, from my perspective, I believe in this scenario, because it is confusing with the 4 different units, I think we have to give the benefit of the doubt with the information in front of us to the appellant as far as the timeline is concerned.
I'm inclined to agree.
So I think that our date, therefore, that, first of all, it's a threshold issue. I don't believe that there was any error in the fact that the permit had lapsed and they missed the grace period. So don't believe there was any error of law on the fact of the zoning administrator.
Right.
Secondly, though, as far as the date that we are operating off of, I would tend to say it is when that 492 listing was removed.
I would agree.
And just to clarify that for a point of a record, the reason I am assigning it to that is based on the evidence that was presented by the appellant as to when he notified his property management company and said, take the listing down, and the listing came down the next day based on the evidence presented today.
Yeah.
Anyone else? Anyone have a solution?
Can I make a comment, please?
Please.
I don't know if it comes into play or not, but if you look at the Airbnb statement, there's a parcel number, parcel ID number, that's property number. If these are 4 units in their condominiums, each one's going to have their own parcel ID number.
Okay.
And if you look, so that's on the front page, about halfway down the right column. So the parcel ID number ends in 100, and apparently, I'm looking at the case page, it also has that same parcel ID number. So I don't know if there's a way to link the Airbnb identification number along with that parcel ID number.
I know the public forum is closed, but I feel like there's a point of emphasis to make on that with regard to the second page.
I'm sorry, the public hearing is closed. I will reopen it, but Sure. Okay, would you like me to reopen the public hearing? Go ahead.
The parcel cited on the STRP appeal ends in when there are multiple units on a single parcel, they often get assigned a CO or something like that at the end. The parcel ID for this one is, in fact, the 105-071D00100. However, there's a CO on the end of this one.
Typically, if you look at the 4 units, you're going to see the 100. Next unit would be 200 CO, 300 CO, 400.
Typically, I would agree with you, Mr. Bray, but I just know that sometimes there is some discrepancy in that.
Okay, with that, I'm closing the public hearing. And is there any further discussion among the board members? Any motions to suggest some relief for this appellant or to deny relief to this appellant? or a discussion of a motion?
Are we operating off the 6-month time period or the 1-year time period with this one? I apologize.
1 year.
I think 1 year would be draconian.
It's the law.
It is, but in this case,
We're open to your suggestions.
the clearest evidence we have that I believe suggests that there was an effort to remove the listing that was successful on March 16th. I haven't gotten as far as how long the waiting period should be.
The 1 year is assessed due to the fact that the permit expired and operation continued, not really whether or not there were documented dates, March or May. That would have certainly made it more egregious.
Certainly.
Which opens, I think, some discussion.
Certainly.
Ron, you have an opinion?
I have an opinion. I think, were they applying for a permit now, and it would be under the 2019 law, they would have 6 months, and I would move that the waiting period they would have would be 6 months from March.
I believe staff corrected our misconception on that. It's 1 year for this permit.
I understand that. I'm saying that I would, if it were done today, it would be under a 6-month period.
Right.
And so I would therefore move that we put that under the 6-month period, so it would be March 16th,
from March
6 months from that date.
6 months running from March 16th.
Yeah, right.
How does that sound?
You know, we did go with 360 days for a somewhat similar case of an owner-occupied DADU STR earlier today. So I'm having a little bit of the justification for relief in this case I'm not seeing relative to other cases heard today.
I get your point. I do believe that in that case, we'd already burned about 7 months of that 360 day, did we not? So in essence, we couldn't really go back and, give them time served. We couldn't really say, let's forget the whole thing. I appreciate your point, but if we're trying to use these dates of violations or the most recent quote-unquote date of violation as a starting point, these appellants have appeared to us just in a very timely fashion as opposed to these other cases that had been lingering for a while. So I don't think these appellants should be penalized because the other appellants had a longer wait time before they appeared before us.
I would also note that in the prior case, we had stays after they got a notice of violation too. And I know that in this one, we had one stay after the permit expired, but it was not after an expiration and then a notice of violation. To me, I think there's an added layer to the prior case that's distinguishable.
Agreed. I think I could live with the 6 months from the March date.
Would you like to make a motion?
Sure. I'll make a compound.
You do it better than I do.
I'll make a compound motion that there were no errors of fact or law in the administrator's determination, and that there be a 6-month waiting period starting from March the 16th of 2021 before a new application can go forward.
Second. Shall we vote?
Yes.
All in favor?
Aye.
Aye. Motion carries.
Thank you, board members.
Thank you, members of the board,
Very welcome.
council member, and staff. I appreciate it.
Thank you all for your time.
Thank you.
Thank you. And this concludes today's short-term rental appeals board hearing.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.